Good afternoon, everyone, and thank you so much for joining our webinar today, Bracing for Regulatory Impact, your DOL Audit Checklist. My name is Amanda, and I'll be your moderator today. ERISA attorney Larry Grigine is our presenter. We're getting a lot of questions on DOL audits already. A couple of you have been emailing me even before the webinar. I know we have a lot of information to cover. Larry has a really packed webinar, so if you missed something, don't worry at all. We'll be emailing everybody a recording and the slides after the webinar concludes. Right now I'll be keeping the webinar muted to avoid any background noise, but Larry will pause periodically for questions. At any time, if you have a question, just type it in the little box below on your screen, and when Larry pauses, I'll read it out loud for you. Our next webinar will be on June 20th at 1 p.m. Central, and we'll be covering wellness programs. For now, I'm going to turn this presentation over to Larry.
Amanda, thank you very much. The purpose behind today is to let you know what the DOL is doing in regard to audits, what they're auditing, what is it like to be audited. And it's a situation where basically you can prepare for it, and the purpose behind today's seminar is to get your act together, get your documentation together, and make sure you're ready in case you get a letter, because many times the DOL doesn't give you a lot of time to collect, and it may be a lot of information they're asking for. So I think the best thing you can do after this seminar is do a checklist, see what information you do have using the slides here, and fill in the blanks, because many times when the DOL, individuals receive the DOL letter, half the material they can't find, and it's panic mode. Now, many times when you get audited and you can't find material, it's not going to be fatal. You're not going to be penalized. In this situation, the DOL will ask you to correct whatever errors they see, and they'll come back within a period of time, either 60 or 90 days, to see if you complied. If you haven't complied, then that's when the penalties may occur. But generally, they'll just ask you to fix any discrepancies or any failings that they find. It's embarrassing for you, it's embarrassing for your employer if they do find errors. The purpose behind this is to make sure you understand what you have to do. So what we're going to do today, we're going to review the DOL Enforcement Authority, the process and what to expect when your plan is audited, what's some of the things you have to look at, what's some of the hot compliance issues, potential penalties if you are penalized, well, what are you looking at, and proactive measures that your employer can take in order to avoid any issues or problems. So in regard to the DOL audits, the DOL has investigative authority under ERISA Section 504. It provides the agency with the power to investigate whether any person has violated or is about to violate any provision of ERISA Title I or any regulation issued in regard to Title I of ERISA. And the DOL may commence an investigation and require records whether or not it is reasonable cause to believe any violations exist. So they're in there just to see if you're in compliance. And sometimes it's random audits. But in most situations, what will trigger an audit, and you'll see a slide later on this, is any answers to the 5500s and an employee complaint. Somebody calls up the DOL and says, my company did X, Y, and Z, and especially disgruntled employees are probably a good source for that. So, I mean, these are ways that, again, what triggers a DOL audit. So under ERISA Section 504, it permits the DOL to investigate whether any person has violated or will violate ERISA. ERISA Section 504 states that the DOL may make available to any person actually affected by any matter to which the subject of an investigation, any department or agency, information concerning any matter to which it may be subject to investigation, so they have to notify you. In addition to its power to obtain documents in connection with the investigation, the DOL has broad general authority to request production of documents relating to the ERISA plan. So they can ask for a whole room full of documents that relate to your plan. So be ready and make sure you have copies of SPDs, contracts, contracts relating, any vendor contracts that relate to the administration of your plan. They want to look at everything when they do an investigation. So the DOL is responsible for enforcement of ERISA compliance. There's 10 regional offices. There's one here. There's one in Chicago. And these are the areas that they have enforcement authority under: COBRA, HIPAA, Mental Health Parity Act, Newborn Mothers Health Protection Act, Women's Health and Cancer Rights Act, GINA, Mental Health Parity and Addiction Equivalent Act, CHIPRA, Children's Health Insurance Program Reauthorization Act, Michelle's Law, and also ACA, Patient Protection Act. So there's a whole bunch of stuff they have authority over, and their purpose behind their audits is to make sure that you as an employer are complying with these rules. And one of the aspects of this that's very important is make sure that the employers are getting the required notices that each of these particular laws require. And there's a ton of different notice requirements, either at initial enrollment, open enrollment each year, and you have to make sure and you have to document the fact that whether you distributed to the employees. Remember, in many of these, it's not the fact that the employee asked for a notice. You have to provide a notice to the employee at various times. And we've had seminars in regard to when those notices, it's not the topic of this seminar, but again, we've had seminars in the past that really detail exactly when these notices have to be given. So what are the types of DOL audits? Criminal investigation and audits. These are in situations where, and generally, it involves plans with assets, and there's an issue or problem with employees of that employer actually stealing money and not providing benefits. Civil investigations and audits, and random audits. And again, in regard to criminal and civil investigations and audits, someone's complained and there's some aspect of it they have knowledge on and they want to get more information regarding what's happening. Now, if you think just because you're a certain size, you're not going to be subject to a DOL audit, please, that's a misnomer. Because employers of any size are subject to ERISA, then you can be subject to a DOL audit. So again, just because you're smaller doesn't mean the DOL may not come in and look at what you're doing. DOL audits on the rise, especially with small and medium-sized employers. This has been true under the Obama administration. And we don't know what the impact of having Trump elected in the White House is doing to DOL audits. But I think because of the enforcement aspect of it, they're going to continue to do these. Now, as I said before, audits can be random, but the following are common sources. Participant complaints, Form 5500 reviews, reviews from other, referrals from other agencies, state insurance departments, adversary groups, advocacy groups can also refer, and I've had a situation where a school district was having employment tax issues with the state, and the state referred federal agencies to follow up. So I mean, also they follow the media, and then also private litigation. If there's individual employees that are suing the employer for various things, they will pick up on this. And again, there's also random ACA compliance random audits, where they want to make sure the employers are complying with all the different ACA rules. So also there's the Health Benefit Security project that was established in 2012. It includes a broad range of investigatory issues such as compliance with ERISA, unpaid and improperly processed benefit claims, excessive service provider fees, systematic denial of promised benefits, criminal misconduct by plan fiduciaries and medical providers. Other common violations are failure to maintain required documentation, failure to provide required notices, failure to provide benefits in accordance with plan terms. And I think that's what's important. especially if you have a self-funded plan, you have to make sure whoever is administering your plan is administering according to the plan terms. Now, with insured, again, you have to check to see if there's complaints that the insurance company is denying benefits that are promised. That's a whole other issue, and you have to confront the insurance company in regard to that. Improper claims adjudication, failure to follow DOL claims procedures, and failure, and this is a big one, to forward employee premiums to providers. In some situations, the employer may wait too long, and there are rules in regard to when those employee premiums have to be forwarded to providers and also insurance companies. Amanda, are there any questions so far?
Yep, just one second. No, we don't have any questions right now.
Okay. So this is what happens when you get a DOL audit. First of all, oops, next slide would be interesting. The DOL audit letter arrives in the mail, and generally they won't call you. They will send you a letter first. And then that letter could be probably as much as 10 pages. There could be a cover letter, and then the document requests are attached to that, and it could be massive. So document requests and or on-site audit, on-site interviews with fiduciaries and other persons with plan decision-making authorities, and then after the investigation, there's a voluntary compliance letter indicating they will indicate exactly what they found and what some of the compliance issues. And as I indicated before, there's going to be a correction period. They'll give you a period of time, 60 or 90 days, to correct whatever they found a problem with, and then once they've come back and they've verified the fact you've made the corrections, then it's a closing letter indicating you've complied with all the requirements. And this could take months for all this to play out. Sometimes they do what we call a desk audit, where they request the information, and then what you do is you communicate with the agent over the phone, and there's no on-site. But many times they want to see, because the documentation they're requesting, they're going to be on-site, and they want to look through the documentation in your files. So when you get a letter from the DOL, what should you do? Notify your legal counsel immediately. If your legal counsel isn't a benefits attorney, find someone who can assist you in this audit, because you need someone who's gone through this before. Work with legal counsel to timely produce the requested documentation. Provide documentation in a complete and organized fashion so they can follow it. Be comprehensive, explain any missing information or documentation. Identify any known compliance problems in advance, and treat the auditor with respect and be non-confrontational. Now, what's important here, they may give you a very limited time to comply, and 9 times out of 10, when I deal with an auditor and we can't come up with the documentation in the time limits, we'll ask for a 2-week, 3-week, 4-week extension to make sure we can provide all the information that they're requesting. And like I said, 9 times out of 10, there's no problem granting an extension. But again, you have to make sure you use that time to produce the documentation that they are requesting. Don't ask questions about what prompted the audit. Don't volunteer any documents or information that's not requested. And please don't ignore the notice. They don't take kindly to be ignored. So please make sure you send that letter and get the resources together, because it could be daunting, all the information they're requesting. It could be 1 year, multiple years, but again, you have to comply with all the requirements of the document request. Determine who will be interviewed. These individuals have to be familiar with plan documents and plan operation, prepared to address compliance issues and or corrective measures. Now, just be prepared in this situation that they're going to find something wrong. Nobody can ever do everything perfectly, so be prepared and have your management prepared, there's going to be something. Now, if your benefits are insured, especially in the health and welfare area, I would have my broker there. And make sure the broker is an important part of the team, so they may want Schedule A's, they may want insurance contracts, and sometimes you may or may not have the most recent contract. Make sure anytime you talk to the DOL, either over the phone or in a meeting, arrange for legal counsel to be present, because they can tell you exactly whether to answer questions and what information to provide. Designate an appropriate location, either a conference room or an office that person can actually review the documents. Make sure that room is comfortable, usable workspace. Avoid any high traffic areas, and make sure you have all documents produced readily accessible, either paper or electronic, so they can actually look at it. And many times what they'll do, they'll ask for the information, and you have to send it to them in order to review it first, and they'll come back with questions. There'll be an informal interview. Make sure your legal representation is there. Make sure that you don't answer any questions unless your legal counsel says it's okay. DOL will ask a series of questions until he has covered his agenda. So again, make sure you're prepared to answer any questions. And if you don't know, don't fudge and say, I'll get back to you on that particular question. If you don't have knowledge of what the answer is. There could be no action letter. They found everything is fine. So there's no ERISA violations. Or there could be a violation cited, however the DOL does not seem fit to take any further action. They just may ask you to correct it. They may say, yes, we've cited violations. There'll be no damages or de minimis damages. They'll just say, go ahead and fix it. Violations decided and corrected following a receipt of a voluntary compliance letter. And in that situation, once they verified you made all the different changes to the plan, then you'll have a voluntary compliance letter indicating you've done this. So once the corrective measures are finished, there'll be a voluntary letter issued, 10 days to respond. And what they'll do in that situation, the letter will indicate what has to be done in order to comply. Proof of correction must be submitted, and it can take a couple of months to come up with all the corrections. They'll give you a period of time to make the corrections. Now, if it's serious, they may again take you to litigation if the violations are serious. 9 times out of 10, it doesn't happen. They'll just ask you to correct any violations and move on. And again, once they come back and check to see if the corrections are made, if those corrections have not been made at that time, that's when the final step of litigation may happen. So plan document requests. They'll ask for plan documents, adoption agreements, rep documents, and amendments. They'll ask for summary plan descriptions and any summary of material modification. For a signed Form 5500 for the past 3 years. All contracts, policies, or arrangements with other providers of service to the plan. So that's why your insurance broker is an extremely important part of this team. Make sure that that individual can help you collect all the different contracts and policies. If self-funded, all contracts for claims processing, administrative services, and reinsurance. Make sure your TPA contract is in place. Copies of all required notices, including lists and logs of issued notices, and a description of policies of procedures for distribution. Plan rules in regard to pre-authorization for hospital stays. That's the insurance company if you're insured. Sample written description of benefits mandated by the Women's Health Act, required to be provided upon enrollment and annually. Materials describing any wellness program, including a disclosure statement regarding the availability of reasonable alternative. If claiming grandfather status, a copy of disclosure statement statement and records documenting the terms on May 23rd. And that's extremely important because if you are claiming grandfather status, you have to have documentation what the plan was in existence on that date and compare it to what your plan is now. So you have to keep all those records of the plan in place as of March 23rd, 2010. Written notice describing enrollment opportunities of dependent children at age 26. That was done in number of 2010-11. If coverage has rescinded any employee, participant, or beneficiary coverage, a list of individuals whose coverage has been rescinded, reason for rescission, and a copy of rescission notice. That's important because under ACA, you can't rescind retroactively unless there's fraud. So they want to look at that. Documents showing lifetime limits in each plan after September 23rd, 2010. That's your insurance contract. Documents showing annual limits for each year after September 23rd, 2010. Documents relating to provision of preventive services for each plan year after 2000. These are all ACA requirements. Copies of plan claims and appeals procedures, related collective bargaining agreements, plan accounting records, log reports for participant claims, summary annual reports for the past 3 years, fiduciary liability insurance, fidelity bond, and names and contracts information for plan actuary, attorney, accountants, insurance agents, and committee members. What they're looking at here is that they want to understand what benefits were promised, whether those benefits were actually delivered, and whether you as an employer provided all the necessary coverage, but also notices that was required under the law. And you have to document each time you did this and make sure that you document when you actually gave out the notices. Amanda, are there any questions?
Yes. Do you have a list of required notices, and is it different for group size, like small group versus large group?
Generally, no. We did a seminar. Look on the list of webinars. We did a seminar in one of the cycles, I think, last year on this. So there is a past webinar that we discussed all the necessary notices.
Okay.
So there's a seminar that discusses that.
Mm-hmm.
And probably I will do it probably one of these other cycles, just go back and look at them again just to make sure everybody understands what to do. Because that's a constant topic, and that's one hot area that the DOL is always looking for and making sure. And there's so many notices. Most employers try to do a good job, but you're going to miss one or two in some instances. Another hot area of compliance issues is COBRA. Notices that are not sent out. You miss an individual often in COBRA. That happens a lot, and you just have to make sure you correct those errors.
Under possible outcomes, is there a possibility of fines and penalties?
There is a possibility, especially if the error has been egregious. In my years of doing audits, very rarely do I see any employer being penalized, but it's out there, and sometimes they'll use that as a threat in order for speed up the process of compliance. Mm-hmm. Also, another area that they'll do is they'll threaten litigation if you don't comply. That threat is always there, so if an employer is slow and getting things back to them, this is the threat they always use. So the most you can do is compliance, and 9 times out of 10, even if there's violations, you're not going to be penalized. They'll just ask you to fix it.
Mm-hmm. What is the fidelity bond?
A fidelity bond, basically, and you may not be familiar with this, it's a bond to hold plan assets. And many health and welfare plans don't have plan assets, so you don't have a fidelity bond. But that's the purpose behind it. It's to ensure that the person handling any plan assets are insured. And many health and welfare plans, especially if your benefits are insured, you won't have plan assets unless you're larger and have plan assets. That's when you need a fidelity bond.
I'm not quite sure what this is asking. I think I might be missing a word. It says, is an ERISA different from ERISA insurance coverage that we elected to have voluntarily?
Well, why don't you get the person who wrote this kind of clarify this, but I mean, there's various types of benefits, and what we're talking about here are those benefits that are subject to ERISA. Now, there's certain benefits that you offer that are voluntary benefits. And these benefits, for example, many of the AFLAC benefits are voluntary. Those benefits are not subject to ERISA. If you comply with the voluntary benefit safe harbor, and one of the aspects, and in that, if an employer endorses the program, then you blow the safe harbor, and the benefit is then subject to ERISA. And one way an employer can endorse a program is allowing employees to pay for those premiums on a pre-tax basis, because those pre-tax contributions are deemed to be employer contributions because they're not subject to tax. So I mean, so that's a concern.
And then one more, is a notice required for an underspent flexible spending account?
There's no official notice. I think you should notify the employee that it's underspent. And an employee should know exactly how much is left over on their account, but I don't know of any formal notice requirement.
Alrighty. That's all we have for right now.
Okay. So the $64,000 question is, what are some of the hot compliance issues that the DOL is looking at currently? One thing, this is an area that many employers in the health and welfare area are not in compliance. ERISA requires that every health and welfare plan must be in writing. So welfare benefits include health, dental, vision, disability, life, health FSAs, health reimbursement accounts, some EAPs, and some wellness programs. Remember that the insurance contract technically doesn't qualify as a plan document. So you need a plan document for all your benefits. Also, governing body, board of directors must adopt resolutions to authorize initial adoption of a plan. And this is something many times employers don't do. They don't go through formal action to adopt these programs. And there has to be, because in order to give the officers the authority to sign the documents, there has to be authority from the employer, the corporation, indicating the fact that they have authority to do so. Approve amendments unless the plan document delegates the authority to amend the plan to someone else. Anytime you change the plan, there should be formal documentation that you've approved that and moving forward, and when those amendments are effective. Generally must be adopted by the last day of the plan year in which the plan amendment is effective. Very rarely can amendment be cross plan years and be sometime way in the past. So generally they give you to the end of the plan year in order to make an amendment. So all that, and one of the things that both the IRS and DOL look at, especially making sure that those plan amendments are signed and dated, because they want to make sure those amendments are in place when there should be, and they have to be done during the plan year. And many times I see amendments and they're signed, but they're not dated. And the IRS and DOL will not accept that as an executed document unless it's dated. So review all your plan documentation to make sure that everything is dated within the time limits that the law indicates. On the ERISA plan document, make sure that you have all the required feature sources that mean fiduciary, any procedures for allocating responsibilities, a funding policy, how payments are made, claims and appeals procedures, and some of these will be contained in your insurance documentation. So again, you have to replicate that. You just have to wrap things around so it it meets all the ERISA requirements. Procedures for amending the plan and identifying who has the authority to amend the plan, that will not be in the insurance contract. For insured benefits can sometimes use the insurance contract as a plan document, but you have to, again, you have to fill in the blanks of what those sections of the plan of the contract doesn't have. They may not have, for example, provisions about who the plan administrator is. They may not have provisions who the named fiduciaries are. And again, what I recommend all the time in regard to this that complies with this is, even if you're under 100 employees, having a wrap document that wraps around everything and you comply with, again, the ERISA requirements. And then every under ERISA plan, summary plan description, SPD, one of the misnomers here in talking to employers, they think, well, the employee never asked for a summary plan description. I didn't give it to me. Never asked. Well, that's not what the law says. The law says that you must, an employer must provide a summary plan description to the employee once they become eligible. And they must be given to employees and beneficiaries within 120 days after the plan is adopted, within 90 days after the employer becomes a participant, and an updated SPD must be furnished every 5 to 10 years, depending on the number of amendments. Most of the time, insurance carriers and TPAs do not provide you with an SPD. You have to provide one on your own. Sometimes they do, sometimes they don't, but you have to check and see if all the required provisions are there. If you are provided with an SPD by a third-party administrator, it should be reviewed by legal counsel for compliance. I do a lot of that review, and I'm surprised to see the different types of SPDs that are floating out there. So these are all the items you should check to see that should be in your SPD. And again, this is an extremely important document, and this is something that the DOL will look for. There has to be plan identifying information, identifying, what benefits are being provided, what the plan year is, well, who's the plan administrator, plan eligibility requirements, plan benefits, cost sharing, co-insurance, all that's going to be indicated. Circumstances which an individual can lose or deny benefits. Amendment and termination procedures, giving the employer, whoever, the authority to amend or either terminate the plan. What are the source of contributions? Employee and employer. Funding, how is the benefits going to be funded? Is it through an insurance contract? Claims and appeals procedures. There's a formal statement of ERISA rights that's in the regulations that have to be in all SPDs. An offer of assistance in non-English language. The role of health insurers and claims administrators. Who has the final authority to deny a claim, and especially an appeal? Procedures for obtaining pre-authorization approvals and utilization review. COBRA notices, Newborn Mothers Protection Act notice, mental health parity rights, women's health and cancer rights. The qualified medical child supporter procedures have to be in the SPD. Family medical leave procedures have to be indicating when you do go on family medical leave, what benefits are continued. And there has to be an indication, especially in medical plans, whether your plan is grandfathered or not. So all this got to be provided in the SPD. Now, what's really important, and this is where I think employers do a poor job. Anytime that you change your benefits, basically you have one or two choices. Either you can give an employee a changed SPD, or if you don't want to do that, you can give them what's called a summary of material modifications, which is basically an explanation of what the change is. If the plan is amended, the SMMs must be furnished to plan participants within 210 days after the plan year in which the change occurs. if the SMM involves a material reduction in covered services or benefits, it must be furnished to plan participants and beneficiaries no later than 60 days after the adoption of the plan. This is extremely important, and this is what the DOL is looking at. Did you inform your employees of any changes? And I'm surprised how many employers change benefits and they don't think about giving employees a copy of explanation of the change, and that's what this is. Explain to the employees what's changed, and especially with health and welfare benefits, most employers are changing one benefit at least once a year, if not all benefits. ERISA claims and appeals procedures, though, if you're insured, those will be in your insurance contracts. Check and see if they comply with ERISA. 9 times out of 10 they will, but there's got to be detail. And what you have to do is you have to give your employees a copy of what those plan claims and appeals procedures are, so they understand what they have to do. Adverse benefit determinations must include required disclosures, reasons why the claim was denied, reference to specific plan provisions. Make sure the insurance company does that. ACA adds additional requirements for certain plans. And again, plan sponsors are ultimately responsible unless delegated to a third party, which is generally the insurance company or claims procedures. But again, you have to make sure everything is done right. And again, these are all the required notices that have to be given out. And we did a seminar a few months ago that details basically when these notices have to be given, but you have to document when these notices have to be given. Extremely important. So in your files, not only a copy of what these notices are, but when they were given out. So again, please, extremely important to make sure that all these notices are given out. Also, the DOL audit requests related to the ACA compliance have been divided in the following categories: requests for grandfather status, documentation of exactly how you're complying, whether you're providing benefit coverage for dependents to age 26. If there's any rescissions of coverage, has it been retroactive or prospective, and what are the reasons for that? And you have to document that. Lifetime limits and annual limits, when these limits were complied with, because there was gradual upping of the limits. Eventually, all of them went away. And again, in regard to grandfather status, records documenting the terms of the plan as of March 23, 2010. The participant's notice of grandfather status include materials that describe the benefits under the plan. For non-grandfather plans, the DOL audits have been requesting documents related to preventive services for each plan beginning after September 23, 2010. The plan's internal claims and appeals procedures, contracts and agreements with independent review organizations or third-party administrators, notices regarding the adverse benefit determinations and final external review, and documents relating to plans emergency services benefit. Again, if you're insured, many of that will be provided by the insurance company. So again, the DOL requests for compliance have been divided in requests for grandfather status, dependent care 26, rescissions, lifetime limits, and annual limits. We've covered this, but it's good to repeat that again. Okay, we've gone through this. Oh, I must be going back. I'm sorry. Sorry about that. So DOL has been requesting the following information from both grandfather and grandfather status: sample notice describing employment enrollment opportunities for children up to age 26, a list of participants who have their coverage rescinded, documents relating to lifetime limits have been imposed since 2010, and also the annual limit. And also they've been requesting information about the prohibition of pre-existing conditions, distributions of summary benefits and coverage, distribution of medical loss ratio rebates, and again, you have to document what you're doing, imposition of 90-day waiting period, and the 60-day notice if any changes are made. So all these notices you have to document whether you've done that or not. Now somebody, Amanda, are there any questions?
Yes, the first one was actually more for me. It was, how do you access our previous webinars? So if you haven't before, you can just, first of all, we emailed them out to everybody if you attended or if you registered and couldn't attend. But if you'd like to see ones that you weren't registered for, you can go to our website, which is benefitexpressonline.com, and then you can just click resources in the top right-hand corner and then click webinars on demand from there. And that'll bring you to a page that has all of our previous webinars in one place. We have recordings and slides for download. Then the questions for Larry. If a government agency not subject to ERISA, would they still be subject to a DOL audit?
No, because the DOL would not have any authority.
Okay. Is there any value to a RAP for a government agency not subject to ERISA?
Well, what you need to do as a governmental agency, what you need to do is determine, because you can pick and choose what aspect of ERISA you want to be subject to. And so you have the luxury of choosing, do I want to keep claims procedures? Because what you need to do to avoid any litigation is you need to document what you're providing to the employees, and you have to communicate that. So even though you don't have a formal requirement to comply with ERISA, you still have to give employees a indication of what you're providing and also document what you're giving them and the limitations. So again, certain aspects of ERISA you may want to comply with only because if there's any confusion or any discrepancies between what people understand you're providing, having it down in paper is a great thing to have.
Great. And then if you have an online benefits portal and all the required notices and documents are there, is that considered providing the documentation to the employees?
What you need to do in that situation, what the regulations require, is you have to send a notice, a paper notice to the employees indicating the fact that those notices are on the internet. And also what you do for any employee who doesn't have access to a computer at their desk, you need to provide paper copies of those forms or those documents to them on paper. Now, at any time, an employee could request a copy of any of those documents, and you have to provide them with a copy of it.
Okay, and that's all for right now.
Okay. Let's go through possible fines and penalties for violations. First of all, ERISA fiduciaries who violate the duties are personally liable for any damages caused to the plan or any profits realized by the fiduciary through the breach. What that means is, in the first question you have to ask yourself, who's a fiduciary? A fiduciary is any individual who has discretionary authority under the plan. So it could be a corporate officer, it could be head of HR, anyone who has discretionary authority in approving plans, designing plans, that's a fiduciary. In that situation, that individual in ERISA litigation can be sued and be held personally liable. Now, generally, what the recovery under ERISA is basically providing the benefit as promised. There's no money damages in ERISA. Is basically, you know, I didn't get my benefit, you promised me a benefit, I didn't get it, I'm going to sue you for it, and it's either coming from the plan or you, the fiduciary. I don't care either one, but you're going to be sued. So again, any corporate officers that has authority under the plan should have fiduciary insurance just to make sure they're protected. Breaching fiduciary may also be liable for special fiduciary penalties equal to 20% of the amount recovered by the DOL under settlement. So again, that's an additional penalty. So, and again, such fiduciaries may be removed from their fiduciary positions and may even be subject to criminal penalties, and especially if they deny benefits to employees who should be receiving benefits. And many times, this is probably more apropos on the pension side, especially for those businesses that are failing. I've been involved in situations where a plan has a employee stock option program and they can't raise the cash, for example, to provide benefits. So that's when employees begin to sue because they're not getting the cash out of the plan because nobody wants the stock. It doesn't happen too often in regard to health and welfare benefits. Now, another area is on written requests by a participant or beneficiary, the ERISA plan administrator must furnish a copy of the latest SPD and SMMs, the latest annual report and terminal report, and any bargain agreement, any trust agreement, any contract, any instrument under which the plan is established. You have 30 days to comply with that request. The penalties are $110 a day after the deadline, and the penalties begin the 31st day after a written request. Now, what's interesting about this, in order for the employee to get this money, they have to sue in federal court. And in situations where I've represented employers, it's very tough for an employer to get payment in this area because they have to show all kinds of intent not to provide these documents. So it's really tough to get this money. In addition to possible criminal penalties for willful 5,500 failures, the penalty is $2,063 per day for each day that the 5,500 is missing. The penalties are cumulative. They assess separately for each missing or incomplete 5,500. While it's unusual to see full penalties assessed, imposition or even reduced penalties can make the cost of non-compliance very high. There's again, a program that you can go through, a delinquent filer program, and the penalties, instead of being $2,000 a day, are reduced down to $10 a day. And the maximum penalty for any plan is only $4,000. So if you see that you haven't filed 5,500s, or you have clients that haven't filed 55, that delinquent filer program is and it's very easy. You just basically you file the 5,500 at normal, and then you file at another place or under the program, pay the penalty, and then you're done. Failure to provide the certifications can result in penalties under ERISA, Internal Revenue Code, and Public Service Act. For plans sponsored by private employers, penalties can include under ERISA. Plan participants and Department of Labor can sue a plan, which is often the employer, to force the plan to provide certifications. The IRS can impose an excise tax of $100 per day. For plans sponsored by governmental agencies, the states are charged to enforcing this. Let's move on. Also, under HIPAA portability, remember, under the portability and non-discrimination, you can't discriminate against someone because of a health condition. And the DOL investigation typically probe HIPAA portability and non-discrimination rules. In that situation, if you found being in violation, the penalty, again, in that situation under HIPAA, is $100 per day. The reason why it's in here because it applies to medical programs. Under COBRA, qualified beneficiaries under government plans may sue to recover COBRA coverage under the Public Health Act. In addition, there can be penalties of $110 a day for failure to provide the initial or the election notices. In all suits in ERISA, the court is permitted to award attorney's fees and interest in prevailing party. Other penalties, consequence of failing to provide an SBC, the penalty is originally $1,000, now is $1,087. If you haven't provided an SBC, now remember, every employee has to get an SBC and every new employee has to get one. So please make sure you give an SBC because that's something that an employee could complain about and you could be assessed a penalty. Now, what do you do to be audit ready? Well, you have to identify an individual to coordinate compliance efforts. Make sure that one person has authority, especially with your employer, to make sure they can get all the documentation they need. Identify all group health plans subject to compliance concerns. When I do documentations for employers and I ask for documents, I am surprised many times that employers can't find certain documentations. I don't know how many times people said, you know, we had a cafeteria plan document, I can't seem to find it. Well, that's not going to be an excuse for the DOL if they ask for that and you can't deliver. Routinely conduct self-audits and correct failures. Make sure you look and see exactly what you have and constantly looking and seeing what other documentation is missing. Retain documentation and procedures that support compliance. Maintain compliance documents in a central location. Respond to participant questions and requests in a timely manner. File Form 5500s timely and accurately. And make sure you document distribution of required participant notices timely and keep records of when you distributed them and how you did so. Make timely updates to plan documents and SPDs. Confirm that vendors are following contract terms and administering the plans in compliance, because remember, the insurance company for their benefits are a fiduciary, but the plan administrator is responsible to making sure that the benefits promised are being provided. Require vendors to immediately report instances of potential non-compliance. Train applicable staff on compliance obligations and procedures to address violations. Work with legal counsel to minimize or correct potential violations. Respond promptly and thoroughly to any governmental inquiry related to health and welfare plans. And if you do receive an audit letter, secure legal counsel for assistance in preparing the audit and negotiating the scope and audit and the corrective measures. It's extremely important you have competent counsel who knows how to deal with the DOL and can go through it and can ask questions for you. Amanda, are there any other questions?
Yes. Penalties for not providing an SVC or other ERISA document to a participant would be the result of something ending up in court, right?
No, it's basically what would happen. The DOL would fine you. An employee would comply, and the DOL would then send you a letter indicating you're subject to the fine.
Awesome. And that's all we have.
And in some of these situations, I didn't go into this as more of a health and ACA requirement. In some situations, there's self-reporting for violations of ACA. So you have to self-report on yourself.
Mm-hmm.
Okay. Any other questions?
Oh, one more. How do you find a good ERISA attorney, Larry?
Oh, I know a few. Here's my contact information. I'm an ERISA attorney. I have a vested interest, but again, there's many out there, but they have to specialize in this area and know what they're doing.
All right. Thank you, everybody, so much for joining us. We'll see you again in exactly 2 weeks on June 20th at 1 p.m. Central, and we'll be covering wellness programs. And that's extremely important because the last 2 or 3 years there's been major developments, and if you're sponsoring a wellness program or you're thinking about it, please attend the seminar. All right. Thank you guys so much. Bye. Bye-bye.